You're watching Good Morning Kenya. This is Eye on Politics. We shift gears now and talk about a whole different issues. Now, on Friday, the Court of Appeal gave a landmark ruling that said that the Deputy Chief Justice, that is Philomena Mwilu, lacked constitutional authority to constitute a three-judge bench to hear the cases of impeachment against Rigathi Gachagua. I want to start with you, Wakili. What do you make of this, and what impact does it have?
Well, I think for the public to understand this, probably it's important to contextualize the factual issues very briefly and why we are there. Of course, there was only one ticket between President Ruto and Gachagua. And therefore, because that's what the Constitution provides for, that if you're vying for presidency, you must show us your deputy. The potential being that if you're not there, you die, you become insane. Whatever reason you move, we'll know who will lead us in your place. But of course, that co-ticket in that instance is a measure, is a voter analyzed ticket, and of course the bias as to who gets more, and therefore get the president. So a presidency is intertwined between president and the deputy. Of course, after a few days and months, probably 2 years or so, or thereabout, there was friction between them, and later Gachagua was impeached. That's the historical aspect. When that process of impeachment was ongoing, the court cases that ongoing, Gachagua obtained stay orders in Kerugoya court. And those stay orders were that the impeachment process should not proceed. Then the file from Kerugoya was brought to Nairobi for purposes of the Chief Justice constituting what we'd call an uneven bench, either 3 judges, 5 judges, or 7 judges. It was chosen that the elective there was 3 judges, and therefore a panel of 3 judges was chosen. The problem started here, where the empaneling power, the empaneling authority in law is in the Chief Justice, not in the Deputy Chief Justice. I want to repeat that because it's basically constitutes the problem. The empaneling authority is in the Chief Justice, and not in the Deputy Chief Justice. Now, in law, there's something called ultra vires, meaning you extend the powers allocated to you, and those are what we call jurisdictional powers. Jurisdiction is a power clothed in you. If you don't have those powers, you can't exercise them. So when we donate powers through law, to you through law, then it means you exercise those powers. If you don't have those powers, you can't exercise them. That's basically what the law says. So if powers is vested, powers to appoint ministers or cabinet secretaries is in the president, can the deputy president appoint cabinet secretaries? That will be the question. And if he does, can they assume office? Consequently, and by parity of the same reasoning, if the power to appoint a 3-bench judge is a bench of 3 judges is in the Chief Justice, can a Deputy Chief Justice appoint and exercise those powers? That's basically what was before the court. The Court of Appeal held, as is the position in law, again, unless that is overturned by the Supreme Court now, is that a Deputy Chief Justice cannot exercise the powers of a Chief Justice. The fact that a Deputy President is deputizing the President and in lieu of his presence and active duty can exercise certain powers. This is the position. Not all powers can be exercised by your deputy. That's what the law says. And therefore, not all powers can be exercised by the Deputy Chief Justice where the Chief Justice is not present, unless you are clothed with the powers in law of the Chief Justice. So when you're acting as a Deputy Chief Justice, you're acting in the place and personality of an appointed person of the office of Deputy Chief Justice, and not assumption of powers of the Chief Justice. And therefore, that doesn't seem, the law doesn't seem to have delegated powers of the Chief Justice to the Deputy Justice, Chief Justice, even if the Chief Justice is not in power or in office, whether sick, out of the country, or for whatever reasons. And therefore, whether the question was, is there an instrument in law or under the Constitution that donates powers of appointment or constituting a bench to the Deputy Chief Justice if the Chief Justice is not there? And there is none. Having found so, it means the appointment of the bench to administer, hear, and make determination on the case facing Gachagua was not available to the Deputy Chief Justice to exercise it. Therefore, it was exercised wrongly and outside her domain of powers. Let me give you a scope of what jurisdiction is. Jurisdiction sometimes is direct and sometimes it's implied. This way. I don't know whether you've lived in the village, but if you go in the village, if you go to a homestead with a dog, call a stranger, the dog will back at you. Yeah. If you run away, it chases you. But it doesn't chase you eternally. It chases you and stops at a point and backs at you as you run away if it doesn't catch up with you. That is. It means it can only exercise, chase you to a certain extent, and if it is enough in its perception, then it comes back to its home, right? And therefore, jurisdiction is exactly that. You can only exercise those powers only to a delineated environment. And if you don't, if you pass that environment, then, of course, you meet resistance. And therefore, jurisdiction is both expressive in law and sometimes implied. The sum total of the decision of court is that Deputy Chief Justice did not have powers to exercise the powers she did in constituting the bench. Now, that is a bigger implication because it's not just the act of constituting. The bench went ahead, the judges went ahead, now having been found to have illegally had the case. So they illegally had the case, therefore they illegally made decisions. It means, therefore, all decisions that were made by the court illegally constituted are null and void. Now come to the fault. What was the position in law as at the time that the Deputy Chief Justice assumed the powers of a Chief Justice? What was the position? The factual position was that the Kerugoya court had made orders that whose implication was that the parliament cannot proceed to debate and impeach the deputy president. I repeat, that as at the time there were orders that stopped parliament from proceeding to discuss, debate, and eventually impeach the deputy president. What does that say about the impeachment? That eventually, therefore, henceforward, and by implication, the impeachment was illegal. So what is the position, therefore, of the removal of the Chief Justice or of the Deputy President? As we speak, and to the extent of that improper or illegal constitution of the bench that had the case, is that the removal of Gachagua, as we speak, was illegal. And what happens, therefore, the subsequent appointment of Professor Kithure Kindiki, subsequently, therefore, the same was illegal. So what happens, therefore, in exercise of the powers of Professor Kithure Kindiki that he continues to exercise now? Subsequently, and by the end of time, it will be illegal because the person who should exercise those powers is the one that should be in office before the constitution of the bench was made. And subsequently, where are we headed to? It is therefore important to know that a new bench ought to be constituted, away from the three that were constituted, now constituted not by the Deputy Chief Justice, by the Chief Justice herself. Yes. When it's constituted by the Chief Justice herself, it will be heard afresh. So it's like a fresh hearing, having set aside the other hearing and all orders that were there. That would be the implication. What then would happen? It means when it is subsequently heard by other three judges other than the one that had, a decision would be made whether the impeachment was legal, the process of instituting the impeachment was legal or not. Remember, it is not the impeachment that is in contention. It is the process upon which the impeachment was onboarded or started in the first place. So there's a question of procedure and the substance. The substance is impeachment happened. Okay. But the procedure towards which the impeachment was done, was it legal or not? Courts can only review procedure. They can't review the eventual decision. But if the procedure was wrong, the eventual decision is also wrong. We say that procedure is handmaiden of substance. It means if the procedure is not right, it doesn't matter what the substance the decision is right eventually, the whole thing becomes wrong. And therefore, we're getting into another political segment where where the deputy president then would seem to have been illegally removed from office, at least by the factual and legal issues as obtaining now. But of course, this case has a long way to go. High Court hears it. We'll definitely have the Court of Appeal to look at it again. And then we have the Supreme Court to look at it again.
Omar, why would someone consider this a win for the former deputy president?
I can say it's a win, Mike. Foremost, I'll say that within the legal realm, we have what we call the fait accompli. I want to say that all this process has already been overtaken by time, as Wakili has said. And I don't really think whether Rigathi Gachagua, the former deputy president, can be reinstated because already Kindiki Kithure, the professor of law, already was sworn in as our vice president. But going forward, if the courts will have to relook at this, most probably they'll find out that the former deputy president was impeached illegally. And part of the orders that will be given will that maybe he'll get all the benefits of a deputy president and also get the political rights to vie. Because as you are aware, if an impeached governor or state officer cannot vie for a political office. So I believe that it will be a win for Geoffrey Rigathi Gachagua because maybe the courts will grant him political rights, that's number one, and also give him the right to vie. But again, Mike, I want to say that it's so unfortunate that those who are supposed to protect the Constitution as put forth by Article 3.1 are the ones who are mutilating the same Constitution. The Constitution in 3.1 says that each and every Kenyan has the right and obligation to protect and defend the same Constitution. You know, it beats logic when a Deputy Chief Justice empanels a bench contrary to the provisions of the same Constitution. As the Wakila said, she has no those powers. So that is why we are here. Then, fortunately, we have great men and women in the judiciary. I can say they are the judicial icons. One, Mumbi Ngugi, Francis Tuyot, and of course the president of the appellate court, that is Daniel Musinga. They gave a very balanced ruling regarding that. They cannot bend the Constitution. In as much as the impeachment of Rigathi Gachagua was a political process, why will someone try to work hand in hand with the executive arm of government so as to make some decisions that will favor one side? I think going forward, our judicial officers and to be particular, the judiciary needs to be very, very much keen on the kind of rulings that they make, because some of their decisions are likely to plunge this country into chaos and anarchy. So I believe that it is a win for Gachagua because at the long run, he'll get back his political rights. Then that one will most probably change the political trajectory in this country in as far as the opposition politics is concerned. Yes.
Yeah. Abdi, this ruling, in what way do you think it underscores the role of Chief Justice in judicial appointments?
Before I go to that, I think my colleagues have mentioned some important points. I just want to reiterate that, number one, the contestation, the gist of this court process is basically a contestation around political power.
Yes.
And I think Thomas said that Rigathi is a winner out of this. I also feel that President Ruto is a winner from this same case, in the sense that it frees or it unties his hand, to pivot to a more stronger candidate who has got, the backing or the grip of his backyard. And I think he can use this, the outcome of this court of appeal process to sort of look for a more stronger candidate, more galvanizing candidate ahead, you know, as he prepares for 2027 elections. Within some of the losses now, you mentioned the winners, some of the losses within from this Court of Appeal case is, I would say, largely the big wigs within the opposition camp. Some of them were counting on the fact that Rigathi will not be able to vie. He's basically politically tied. And once he gets back his political rights, maybe at the end of this court process, they will be in for a shock. They will be forced to go to the drawing board, back up to the drawing board, and then sort of reorganize and basically negotiate from a weaker position as opposed to the way they were before the current Court of Appeal ruling. I'm not a lawyer, but I will say that sometimes the law is how you basically argue. I remember once when this bench was constituted, at least the argument in the country or in the media was that, and the lawyers were arguing, I think, in various forums, yes, that the DCJ had, the powers to constitute such a bench. And I think because of that momentum, because of that prevailing environment as of then, I think it may have, sort of encouraged or pushed, the DCJ to sort of empanel and form this bench of judges. But I think ultimately, let's not, lose sight of the bigger picture. The bigger picture is the 2027 election, the contestation for political power. The court process are just, politics by other means. And I think overall, out of this entire process, I believe President Ruto and his government stands to benefit more. Practically, the ruling has no political practical effect. If I want to put it that way, in the sense that the government will continue to function. The only danger is that you are operating with a deputy president who has got legitimate questions around him, and should anything happen, what? That is the only sort of concern for me. But I think politically speaking, this ruling has got practically no practical effect, and actually it strengthens the opposition. I think it favors them. It actually strengthens the government more than it strengthens them.
Indeed, and also, Wakili, there's an aspect of constitutional interpretation and judicial authority. Where does that leave those two aspects based on this ruling?
I think that begs the question as to what is law. So law has its facets. Facets, it is for us. It has to be in writing, in a text, and obviously promulgated in a certain nature, such as then it is binding. It has to be organic, and therefore it must serve humanity. It's not just there for being there. It's not a text for being a text. It's a text that should serve humanity when called upon to serve. And therefore, law is made to serve people. Law is made in different ways. There could be a law that prescribes the mischief that we need to tame. For instance, if we say a president shall serve for 5 years of 2 terms and not anymore, we are reacting to probably the presidency of Moi, who served for 24 years, and the certain things that we didn't like over that time. Yeah. When we say a chief justice will be of this age up to this age and must be of a certain quality, we are really, we've seen how chief justices have reacted before, and we are reactionary within the context of making the law on the mischief that we're trying to tame. Sometimes our law is progressive. Our law is progressive because then we probably forebode and see the future of the society. What do we do, for instance, with the youth movement, the economic aspects, marginal societies? So we react to social circumstances, and then confine that in terms of boundaries, where it starts, where it stops, and how we equalize with the society. So look at Northeastern, how does it become part of the economic benefit of society? Look at Central, look at Western. We try to put that together into some form of legislation or law, which we call a constitutional piece of legislation or whatever it is. But it should be binding. But number two, at the interpretive part, which then the courts come in, is where then you look at the law in the context of the case and society at the time. Because a law made now, same law that is interpreted now and 10 years later could have different results because of the contextual element. The context here is that we're in a situation where we are testing the law in the context of a political rift between a president and his deputy. What are then the boundaries of the president to exercise powers, the boundaries of parliament, and the boundaries of people clothed with powers, including the courts, the judiciary itself? Look, this is a judiciary, power not exercised by, probably the Inquisition is not on a power exercised by any other party other than the judiciary itself and its officers. So I like the fact that there's a pronouncement that seems to be in the context of its own officer, the judiciary's own officer, who's the Deputy Chief Justice, telling the Deputy Chief Justice that you do not have power to constitute this bench. Constitutional powers can be exercised, but you see, there is no chalk that writes this is the end. It is an implied. It has to be logical. So you apply law within the logic. And therefore, if in the interpretation of Chief, which I think she considered, she definitely sought opinions as to whether I can constitute the bench. And I can tell you, the interpretation of law, unless said by courts, and I'll come to that in a few, lawyers have many ways of interpretation, depending on how you're instructed. So what you tell me, I may take a position, but if I had a different position or a different client, I would take a different position. So if she took that position, she had a contextual consideration at the time, and he may have seemed to be right perceptively. But then you need a neutral arbiter who is not part of the disputants, including the Deputy Chief Justice herself, and those that were probably questioning the powers that she exercised. And therefore, the neutrality of courts would be to say the law as is in that contextual position, which means, therefore, what is law? Law is what the judges say it is, eventually. Law is what the judges say it is at an interpretive environment. And therefore, that becomes the order of court. An order of court is an order that says the law says this, and the boundaries and rights are delineated in a certain manner. Subsequently, therefore, and I'm saying this because for me, the things that are in books in law school. Why scholars will say law is what the judges say it is because when the judges pronounce it themselves within the context of a bench and a judgment and an order, that has a force of implication within the society. That's why judges are said they cannot make and pronounce themselves in circumstances where their orders cannot be implemented. They must be organic, they must be for the society and serve society. Progressively, therefore, even as we have many schools of thought among lawyers, but judges are also lawyers, you must pronounce yourself to serve society, that the legislation is organic and you make the law to be available for service to the people, and not the other way, that the law is served by the people. In the context here, back to your question, will be that I think it's a progressive decision that has not looked at the politics of the day, but what the law says. I think we should agree. And remember, it's not the final. This position can be overturned or, again, held as it is, as the law, as the position of law, if it goes to the Supreme Court. So we would hope that it's a position that is, again, tested at the highest office so that we have the highest position, possibly position as beneficiaries of this practice of law from the Supreme Court. I hope it goes to the Supreme Court for further interpretation. But as matters stand, yes, the DCJ did not have positions to constitute the bench.
Okay, gentlemen, and that was our time, and I hope we had more time to talk about these issues. I will give you each 30 seconds to give your closing remarks. I'll start with you, Abdi.
Thank you. I think ultimately this court process, when it runs its course, the winner will be the constitutional order.
Yes.
The winner will be Kenya, and I think it will strengthen our political culture. It will strengthen our, law environment, and I think we should support, the process which irrespective of the camp that we are sitting in, ultimately it benefits, I think, the country and the bigger picture.
Yes.
Thank you.
Amam.
I like to tell our leaders, more especially the president, to first of all concentrate on working to Kenyans, because that's what he was elected to do. It's not time for campaigning, because if you can see, Mike, the country is in a period of political schizophrenia, in the sense that politicians have now started campaigning, and the development agenda has been put aside. So to our leaders, we love you. Kindly work for Kenyans, because that's what you're elected to do.
All right, Wakili.
Thank you. Ultimately, we must be proud of our constitution. We may have questions here and there, and there's no constitution that's ever ideal. It will be the best, no. But I think we have a very progressive constitution. We've not even used it. I would say probably the utility is at 50%. What it provides, we can use. So at every time, I would incite Kenyans to go to court at every time that there's transgression of their rights. Use the constitution, use the law, so that then we can be as progressive as possible. In terms of what, even this is knowledge. This is knowledge to another president, or even the current president, and the DCJ, and whoever it is, when faced with a similar situation in future, he has a reference to what will be my powers and what are my boundaries. Nothing wrong with making decisions. If they're right, they're right. If wrong, and made in good faith. I think if tested, we must be able to agree with what the law would be and the delineation of our rights, the start and the stop. Ultimately, it is about the law that brings us together and creates social order.
All right. Gentlemen, asante sana for making time. That is Wakili George Kithi, who is the advocate of the High Court, Thomas Omar, who is a political scientist, and Abdi Hakim Bishar, who is a strategic political analyst, joining us here on Good Morning Kenya for Eye on Politics. This is where we end this conversation. Don't go too far. I'll be coming back with yet another conversation about investing in the future. Stay with us.